It's 12 o'clock on Tuesday, January the 23rd. The House Criminal Justice Subcommittee is now in session. Wake up. Welcome back, everyone. Madam Clerk, please take the roll.
Representatives Davis, here. Fritz, here. Gillespie, here. Hardaway, here. Howell, here. Holsey, Johnson, here. Lamberth, Hardaway. Moody, here. Russell, here. Towns. Chairman Doggett.
Present.
Chairman Doggett, you have a quorum.
Thank you very much. Welcome back, everyone, as we begin the second half of our session for this year in the House Criminal Justice Subcommittee. Members, do we have any personal orders prior to beginning? Representative Davis.
Thank you, Mr. Chairman. I would like to introduce my intern, and her name is Genevieve Turner, and she is from the University of Tennessee. Genevieve, thank you.
Any other members? Representative Hardaway, good to see you.
Good to see you, sir. Just want to make sure my moms know that I see you, and thank you for being here.
Anyone else? Well, as we begin this year, we've had some changes in staff and support staff for the committee, so I'd like to introduce our new research analyst, Mr. Ryan Baird, sitting to my left here. We also have staff attorneys Michelle Fogarty and Alexandra Greenberg that'll be with us this year. Our clerk, Alora Stewart, is with us. And then our intern is Rose Corres. So without further ado, we'll go to our Sergeant of Arms, Mr. Tyler Muniz, for our weekly words of wisdom.
Good afternoon, everyone, and Happy New Year. Today's words of wisdom will be coming to you from Ronald Reagan. Freedom is the right to question and change the established way of doing things. Have a great day.
Thank you for that. All right, members, diving right in, let's take care of a few things right out the gate here. Item number 6, House Bill 1149 by Representative White will be off notice. Item number 7, House Bill 113 by Representative Russell, off notice. Item number 12, House Bill 971 by Representative Thompson is off notice. Item 13, House Bill 480 by Representative Chisholm is off notice. Item 14, House Bill 1397 by Representative Harris is off notice. Item number 11, House Bill 279 by Representative McKenzie will be rolled 2 weeks. Item number 5, House Bill 1384 by Representative Reagan, roll 1 week. Item number 1, House Bill 1641 by Leader Lambert.
Thank you, Mr. Chairman.
Motion and a second.
Thank
now
you
are recognized. We're a little rusty. Here we go. You're recognized.
All right, members, it's a very straightforward bill. It is an issue out there in the criminal justice arena when a judge orders someone to have certain bond conditions, no contact, no return to the place they're alleged to burglarize, something like that. When they violate the terms of that bond, all an officer can kind of do is just write up a report, and then a motion is made and it gets back into court sometime weeks or months later. This was allowing an officer, if they have probable cause, they have to know that the person was on bond conditions, they have to know what those conditions were, and they have to have evidence in front of them that that person has violated the bond conditions, and they could cite or arrest them for an A misdemeanor. That's what the bill does.
Thank you for that explanation. Any questions? Representative Hardaway.
Thank you, Chairman, and thank you to the sponsor for the bill. How would this apply to possible violations of protective orders for domestic violence or related offenses?
I'm going to go ahead and say this just because it's the first committee back, but you two can continue on. You don't have to ask for permission. If we get off the beaten path, I'll reel us back in. But go ahead, Leader Lamberth.
Mr. Chairman, that's putting a whole lot of trust between Representative Hardaway and I, but I mean, you may or may not get the gavel back the whole rest of the time here, but we'll try. Representative Hardaway, thank you for that question. And so if someone gets an order of protection and it has already been served upon them, it is a crime for someone to violate that order of protection now. If for some reason the alleged victim in that circumstance did not pursue an order of protection, but they had a no contact order through the court, and many times victims will feel like that covers them and protects them just as much as an order of protection does, unfortunately it does not. And so this actually makes it mirror more the circumstance like the order of protection, but without that. So it is a lawful order by the judge who has evaluated the circumstances and said this bond will have these conditions. The defendant has been notified of that. And again, an officer would have to know that that condition exists and have evidence that they have violated it before they would have probable cause for this misdemeanor offense.
Thank you. And I've had any number of instances where victims and potential victims have been put in situations where they have needed law enforcement, called law enforcement, and there has been no relief, so to speak, because of paperwork issues. And we know that paperwork is important in justice, but there are some situations which demand an immediate response and protections from our folk. So I'm going to support your bill, sir.
Thank you for your support, sir. Thank you.
Chairman Holsey.
Thank you, Mr. Chairman. I'm kind of uncomfortable here. Russell stole my seat. And I just wanted to ask a couple questions. One, would this automatically revoke the original bond on the charge? And is that something we ought to look at to plug in there? I think that's a good idea.
Thank you, Mr. Chairman. This would not automatically revoke the bond. So this would create a new misdemeanor offense. And then if the bond needed to be addressed, then the same procedure that would happen now, the district attorney would have to file a motion. That would have to be filed upon the defendant. They would have to get back to court. And then the judge would make a determination whether or not the bond should be revoked or amended in some way as through that process.
Okay. Is this a custodial arrest or a misdemeanor citation, or does it matter?
It could be either one.
Okay.
Representative Johnson.
Thank you, Mr. Chairman. I have talked with attorneys who have concerns that this kind of creates a presumption of guilt instead of innocent until proven guilty.
If you don't mind explaining how on earth that would do, this is a new misdemeanor offense that there would have to be probable cause, but the presumption of innocence absolutely is attached to that. The state would have to prove this beyond a reasonable doubt before someone can be convicted of that. The state would have to prove, these individuals are innocent until proven guilty of violating bond conditions, but unless the state can meet that very high bar, which is where it should be, they would not be able to convict on an offense of this nature.
Thank you.
Any other questions for the sponsor on the bill? Seeing none, we're now voting on sending House Bill 1641 on to full criminal. All those in favor say aye.
Aye.
Those opposed? The ayes prevail. You move forward.
Thank you, Mr. Chair, members of the committee.
Item number 2, House Bill 1642 by Leader Lamberth.
Motion.
You are recognized.
Thank you, Mr. Chairman, members of the committee. Right now, when someone is arrested for an offense and they go before a magistrate, the first decision that is made is there probable cause that the offense has occurred? The next decision that's made is what bond, if any, should be applied to that person. Should it be an ROR? Should they be released on their own recognizance? Should there be any sort of a cash bond applied to them? Should there be any conditions of that bond, like a no contact, no alcohol, no drugs, no return to a certain place? All that is made. And as part of that, when they're determining the bond, the safety of the community and several factors on one side are considered with whether or not that person is going to show up to court on the other side, and those are equal. This bill would say that the first thing they have to look at is safety of the community. So in other words, if someone is convicted if someone is arrested for an offense that they obviously have not been convicted of at all, but they've been arrested for it and there's probable cause for it, and they're alleged to have committed 6 murders. and they have a lengthy criminal history. Well, that person's bond and bond conditions would be drastically different from someone who is arrested on a shoplifting, who has never committed any crime before, and has a long, history in the community. So there's a number of bonding factors that are considered. We're not changing those bonding factors. We're just saying the safety of the community would be the first thing they looked at, and then they would still look at all of those mitigating and enhancing factors below that for purposes of setting a bond and bond conditions.
Any questions for the sponsor on this bill? Representative Johnson.
Thanks. Just for clarification. So you're saying that nothing has changed in this bill. It's just the sort of the hierarchy or the order of what you look at first, correct?
Go ahead.
It changes several things in the code, but that is the primary what this does. It just says, look at public safety first, but then look at all the rest of that. And so if the person has a lengthy residence in the community, if they have a lot of family support, if they've never been arrested for anything before, all that stuff's still getting looked at. This is just the first thing they're going to look at. And really, I will say this goes more to conditions of bond than I think it will go to amount of bond, because there are magistrates that are kind of hesitant to say, well, put a no contact, or I know my friend from Shelby County has fought for years on GPS monitoring for certain offenses. Some are hesitant because they feel like, well, bond's all about showing up in court. Well, yeah, that's part of it, but it's also about the safety of the community and for those conditions that are necessary.
Any other questions for the sponsor? Representative Hardaway.
Thank you, Chairman. If you don't feel that shudder, it's because I'm fixing to support a second bill of Leader Lambert. Setting bond has always, and this comes from conversations with prosecutors, defense attorneys, et cetera, has always been a difficult thing in balancing safety issues of public safety, the safety of the individual accused, will he or she show up for the subsequent proceedings, court proceedings. And for me, it's the priority needs to be in favor of public safety, okay? And when I say public safety, that's collective and individual. Is that person likely to, and that degree of likely can go up and down, to commit an action that's going to hurt somebody? And I'm going to support this bill for that reason. I think our judges need to look at and get into the nuances of who this person is, how they performed in the past, which of course is indicative of their future performance. And I'm back to domestic violence again. I don't think setting $1 million bond is going to stop some nut from being violent towards a woman, and he or she is, I said a woman towards a significant other, and he or she is driven by emotion. That money doesn't make any difference to them at the time of the action at all. So I think there needs to be a fair evaluation. Is this person a danger to the community, to themselves? And then we get into, will they show back up for the proceedings? So I'm supporting your bill, sir.
Go ahead.
And thank you very much. We've worked on a lot of legislation together over the years, and I appreciate your support. I do want to indicate in here that throughout, we are still keeping the protections in there that require the court to set kind of the lowest conditions possible that will ensure the safety of the community and that the person will appear. And some of the language in there is then the magistrate must impose the least restrictive conditions of release that will reasonably ensure the appearance of the person is required and the safety of the community. There's other language that indicates that if the magistrate determines that the conditions of release are necessary, then the magistrate must impose the least onerous conditions. So again, the goal is again, these people are innocent until proven guilty, and we don't lose that at any stage of the process. So it's got to be the least onerous conditions necessary, but it's the first thing they got to think of is how are we going to keep the public safe?
Any other questions for our sponsor? Seeing none, we're now voting to send House Bill 1642 to full criminal. All those in favor say aye. Aye. Those opposed? The ayes prevail. If you wish to be recorded as a no, please see the clerk.
Thank you, Mr. Chairman, members of the committee.
Item number 3, House Bill 1643 by Leader Lamberth.
Thank you, Mr. Chairman, members of the committee. We had a snow week last week. As y'all can tell, I worked on a lot of bills, so I put a lot of stuff on notice this week. The clerk was kind enough to send us an email saying we could email the chairman and put bills on notice, and I took her serious. So I apologize for taking up so much of the committee's time. This bill comes from consultation that I've had with different district attorneys and judges throughout the state and attorneys. 15, 20 years ago, we paid for misdemeanors, alleged offenders who are charged with misdemeanors to get mental health evaluations. We as the state paid for that. We as Tennesseans paid for that. In difficult budget years and years past, they have gone away from that. I think that was unfortunate, and what has been proven out is our local jurisdictions are simply not paying for those mental health evaluations. So folks are not getting the help that they need. They're coming in and out of the criminal justice system by, again, just anecdotal evidence. In some of your larger cities, it's 100 to 200 people that are just in and out of the system over and over again with misdemeanors, but they have severe mental health issues, but nobody's paying for those evaluations. This is a bill that passed through with bipartisan support during the special session. My hope is that it will pass through both chambers, both the House and the Senate this year, and become law. So that is what it does, members, and the fiscal note is a little different than it was in the special session. It was $2.5 million before. It's $3.3 million now. Now, it's a $56.2 billion budget. $3.3 million is simply worth it for us to be able to get these folks help, and I am convinced will help both save their lives and others because they'll get the help they need long before they commit violent offenses. If you're wondering why they increase, it's not inflation. There's lots of those issues going on out there. It's because we're now in a full fiscal year. And so I asked that question of fiscal review, why would it go up, so much in just a few months? If we had passed it before, it would have taken in a portion of a year. Now it takes in a full year, which is why the $3.3 million.
Thank you for that. Representative Towns.
Mr. Chairman, thank you. On the surface, the bill sounds to be very good. Question for you. At what point do we determine that these people have some kind of mental challenges and how are we going to ensure that they get the help? What if they refuse to help? What do we do?
Yes, sir.
So unfortunately, for many of these folks, if they refuse, there's not a lot that you can do except for if there is medical evidence that a judge feels like they should be involuntarily committed, these evaluations will show that. For a lot of these folks, they'll go in for a 30-day evaluation. They do an initial evaluation at the jail. So an attorney's meeting with the client, just that person's not able to really understand what's going on. Usually the attorney is the one that will then come back to the court and the state and say, look, I've got a client who I really need to get evaluated. The initial evaluation, and this I'm describing what happens in Sumner County and I think throughout the state, is that then someone would come down and meet with that individual in the jail. Would do an initial just kind of quick evaluation. Yeah, looks like they do have some problems here, and would make a recommendation for a more inpatient evaluation. Now, that's not done through a committal or anything like that.
Right.
It's done just through a furlough from the court.
Right.
And so and usually everyone agrees. I mean, the state, the defense attorney, the judge, everybody says, okay, we've got a medical professional that said this person needs an evaluation. So what I'm talking about is us paying for then that 30-day evaluation. And in most circumstances, they'll get them on the right medication. They'll get them the help they need. They send them back to the jail from that furlough and with a plan of treatment. And either their case is resolved through some sort of plea agreement because they can understand things, or they go forward with a trial, but they've got their senses about them. And that if a sentence is then put down by a judge, the judge can make that part of the probation.
Right.
Now, the circumstances where they can assist in their defense, there's another bill we'll have maybe next week that talks about those circumstances.
Yes, sir.
Mr. Chairman, I like the way it sounds on the surface there, and I hope it does some good because obviously we need it now. The question also becomes that will there be follow-up on these particular people, these 300 or what have you? Will we follow up with them after they've gotten the treatment that we're going to give them or provide for them?
Yes, sir.
Is that included in the bill anywhere? Or?
Thank you, Mr. Chairman. So it is not included in this bill. It is included in the statutes where if someone is convicted of an offense and they're put on probation, then mental health treatment and follow-up can definitely be a part of that. Now, that's up to our local judges. That's up to, the attorneys. I mean, again, we're still dealing with, and in everything we deal with in this committee, or just about everything, these folks are innocent until proven guilty. Just because they have mental health issues does not mean that we set aside their innocence.
Absolutely.
The state still has to prove their case. But if they are able to do so or they enter a plea agreement, these mental health recommendations from this evaluation can definitely be a part of that sentence.
Absolutely. Now, finally, Mr. Chairman, the 300 plus people that we're tracking, just say nationwide or even in the state, have we looked at what is the probability that they will escalate into greater crimes? Do we have any data on that? You may have not had an opportunity to look and delve into it, but I would be interested to see if there is some data that shows that if we don't do this, eventually this leads to this, and you got a percentage here. Do you have anything that will address that?
So nothing more than, almost 20 years of practicing law and criminal justice, I've seen this happen. We've all seen it in our communities where you get that person who gets in the criminal justice system, they have some pretty severe mental health issues, and then it just escalates over time. Now, the numbers that I mentioned were really just from a conversation that I have had with the district attorney in Nashville of somewhere 1 to 200, in that range for Nashville. Statewide, you can look at the fiscal note. We're talking in the hundreds, probably not in the thousands of folks that need this, but my goodness, they're folks that really, really need it.
Oh. Well, finally, a little anecdote here. Years ago, I might have said this on the House floor before, many, many years ago, my grandmother worked at a hospital that dealt with, the psychiatric, the mentally ill, and things of that nature. But that went away. The hospitals went away across the state. There was no place for them to go. And as a result, we start seeing an increase in certain crimes on the streets and in various places, and they end up in jail, which therefore overcrowded the jail. But that's not where they really needed to have been placed. They needed help. It's just like if you have a heart attack or, God forbid, or any other kind of issue with your body, it needs to be addressed. And hopefully this will do some good as it relates to those, kinds of things that we see early that we can catch and prevent anything that will escalate and make it more dangerous for our society. So I want to sign on to the bill.
Thank you.
All right. Thank you, Mr. Chairman.
And Mr. Chairman, to be clear, the fiscal note says 363 is what they estimate.
Right.
How many people statewide? Again, it's an estimate.
Okay, thank you. Representative Hardaway?
Thank you, Chairman. This will be the trifecta, and then I'm going to take my leave because something's wrong here. But like Leader Lambert, I've had time to read his bills too. And this one makes sense. It's a wise investment in the criminal justice system, and it increases the effectiveness and the efficacy of our justice system. We know that if we catch our citizens who need help on the front end, that we're less likely to adversely impact the rest of their lives and the justice system itself. The resources that it takes after an individual has been in the system, and then you're trying to figure out what's wrong, quite often that leads to recidivism, and we still don't know what's wrong. So I appreciate this bill because by Leader Lambert, because it complements an effort that we're underway with in Shelby County, where our Shelby County Commission, our criminal court judges, our juvenile court judge are part of an effort led by Shelby County Commissioner Erica Sugarman to catch those who need help on the front end. That means to be able to evaluate, identify them before they are all the way through this portal and into the full criminal justice system. If we can do that, then that's what we have to keep in mind that justice is for both sides, for the accused and for the state or for the victim. So it's the best way to deliver justice, make it more efficient and make it more effective by identifying and thus making this help available to the accused on the front end. And I think Representative Towns summed it up quite nicely, that we would do so if it was a physical, medical issue. We wouldn't take someone having a heart attack and just throw them in the cell and tell them, hey, we'll get to you tomorrow. So we have those issues that we need to have the same type of sense of urgency for that are mental health issues. So thank you, Leader Lambert.
Thank you, and look, this is just my third bill now. There's an opportunity on the next one as well, but I would only ask for your vote on this one at this time, so thank you.
Any other questions for the sponsor? Seeing none, we're now voting to send House Bill 1643 on to full criminal. All those in favor say aye.
Aye.
Those opposed? The ayes prevail. You move
Thank you, Mr.
forward.
Chairman.
Item number 4, House Bill 1663 by Leader Lambert.
Motion.
You are recognized.
Thank you, Mr. Chairman, members of the committee, and I know it's our first meeting back, but this is the gravest type of bill that we could possibly consider. When talking about the death penalty, it is the ultimate penalty that any society can allocate towards an individual who has gone through the entire system and been found guilty of an offense. This would say that if an adult over the age of 18 rapes a child under the age of 12, then in the state of Tennessee, if certain aggravating factors are met, the same aggravating factors that are there for homicide at the current time, then the jury could make a determination that that individual would forfeit their own life and be put to death by the state of Tennessee. I don't take this bill lightly. This is something that came from, quite frankly, years of analysis and conversation with folks in my community. It is one I ask that you support, members, if possible. We're going to protect our children in the state of Tennessee. If someone rapes one of our children, they are forfeiting their own life. Period. End of story. And let it go out far and wide that if this passes, we will fight this all the way through the court system and to the U.S. Supreme Court, so that hopefully every state in the union has the ability again to set the penalties in their own state for what the penalty for child rape would be. Again, if this bill passes, the penalty for child rape will potentially be death.
Thank you. Chairman Holsey.
Thank you, Mr. Chairman. Leader, I appreciate what you said. Seems to me like this is an exercise in reclaiming a 10th Amendment to the Constitution, and it's almost an act of nullification. And I just want to tell you I appreciate that very much.
Thank you, Mr. Chairman, and thank you, Mr. Chairman. It is something that the states absolutely should be able to do and set penalties on these type of horrendous crimes. Unfortunately, there is one U.S. Supreme Court case that when it was evaluated, it was a 5-4 decision. And the crux of the argument in that decision was not that necessarily it is wrong to have this type of penalty, but not enough states had this type of penalty on the books. That is something that is up to each state. If other states do not want to have this as a potential penalty, that's their decision. That's their decision for their state. But here in the state of Tennessee, I think we should value our children and we should protect them from these type of child predators.
Representative Fritz.
Thank you, Mr. Chairman, and thank you to the sponsor for the courage to bring this. I know we've talked about this. You did not take this lightly. I appreciate your courage. I appreciate the fact that we're willing to say we did not accept pedophilia in Tennessee and that we will hold you harshly accountable. So thank you for your courage.
Representative Johnson.
Thank you, Mr. Chair. This crime is a 100% time crime, correct?
Yes, sir.
Yes, I believe so.
So if they were sentenced to life in prison, they have to serve life in prison, correct?
Yes, I believe so.
Thank you. So have you talked to any victims groups that do work with victims about this legislation and how they feel about it?
Yes, I have. And amongst the community of individuals that assist with victims of these type of crimes, you will get a variety of answers. It is a very difficult thing to try to ask them to wade into this. What they want is for these crimes not to occur. What they want is for these children that have been horrendously attacked, many times by those that love them or are supposed to protect them, for that not to have happened. And they pick up the pieces of broken lives every day. So I've tried really hard not to put this on their shoulders because, quite frankly, this is a policy decision for us as elected officials to make. But it is extremely difficult, regardless of what the penalty is, whether it's life imprisonment, whether it's death. It is unfathomable. And I want to thank all of those groups that help children that have been sexually abused by these predators for the help that they give to these children for a lifetime, even when they're an adult. Because it's something that none of the rest of us can truly understand. And so, yes, I've talked to them, and it is mixed as to how they feel about these. But again, I feel like we should all come together and support those groups and support these children, while at the same time we are making a policy decision on what the penalty should be for these horrendous crimes.
Well, these people do definitely have to be held accountable. We can do that with life in prison. The concern in the victims I've talked to come to when much of the time with this particular crime, it's familial. And if there is a young child who was raped by an uncle, say, and the uncle's going to say, don't tell because then I'll be killed, I'll get the death penalty. And then you'll have the mother of the child, who's the sister of the perp, who maybe won't want to testify against her brother if it means the death penalty. Victims fear it will create a chilling effect on reporting, that some people, especially in family situations, will not report. They're also concerned about it re-victimizing the victim every time an appeal comes up. They have to tell the story again. We're already talking about, a 12-year-old that might have been impregnated. Not only is she victimized every day by the state that's going to require her to carry that pregnancy, but then they're going to require her to show up for appeal after appeal. And it does make a difference here. It is a heinous crime, and I hate to think about it. But life in prison also takes care of the situation. And I am very, very concerned about young people and families being traumatized over and over, and for them not to report for fear of a relative being put to death instead of life in prison.
Thank you for those comments, and obviously I respect everyone's opinion, and you have one vote just like I have one vote. But the chilling effect that this will have is that, again, let the message go out far and wide. If you rape a child in the state of Tennessee, you will die, period. And if it saves even one child from going through that, because the fear of that gets into the head of some monster out there that's even thinking about this, then it's worth saving that child. And I will tell you, life in prison for these evil people is simply too good. They should not be able to live out their days with the rest of us, including their victim, paying for their food and housing and care and medical as they age and everything else. If you rape a child, you should die. I say that with the most gravity, and I get it. It is a difficult issue. I know you and I will agree that the penalty should be harsh on these, and we may disagree on what the penalty should be, but I hope that today we will support a bill that says, again, if you rape a child in the state of Tennessee, then you will forfeit your own life. That's your choice as a pedophile. That's your choice to do it. Our choice is to put that out there as a possibility.
I just feel that we are going to be risking too many victims afraid to come forward who will be victimized every day for the rest of their life. And so you want this one, in this one situation, you want this to happen, but it's not what we're hearing from victims. So this isn't honestly about us. It's about what these young people have to go through every single day of their lives, and every time they have to show up at an appeal to tell the story, especially if it's a family member.
Go ahead.
This is from a victim. Please support House Bill 1663. I am a victim of child sexual abuse. The wounds are unimaginable, and the scars run deep. These are not crimes that victims are able to heal from or move on with their lives. These are crimes that change children forever. I have struggled and watched other victims as they struggle to establish a sense of worthiness and self-love. These are basic needs that strip children to their core and impact the trajectory of their lives. It impacts their self-worth and their relationships for the rest of their lives in some way. Even those of us fortunate enough to heal enough to love ourselves and gain the confidence and worthiness needed to have healthy relationships, it still impacts how we see and trust the world. Some things can never be gained once lost. The people that commit these type of crimes against children do not rehabilitate, and this is her words, not mine. They simply get better at victimizing children and hiding who they really are. When I was younger, I believed anyone could be rehabilitated even though I had suffered tremendous abuse. However, I grew up in time with experience taught me different. People that commit these crimes are rarely, if ever, even convicted. It takes tremendous evidence against these type of criminals to ever get charges brought against them. The ones that are convicted are typically released quickly or given lesser charges, so they are right back out doing the same things they were doing. Never missing a single beat, they stack up victim as if they were an all-you-can-eat buffet with the type of appetite of a bear coming out of hibernation and only having access to a single plate. There are many victims, however, are forever changed. All that to say, the ones that actually get convicted should face real consequences. Perhaps if that happened, there would be less people in our community forever changing our children in ways that are unimaginable. Our world will be more healthy. I implore you to support House Bill 1663 for all these reasons. I haven't walked in this young lady's shoes, but she emailed each one of us as a committee, and she's lived this. So, I respect what you've said, but I'm going to stand with this victim, and I brought this bill, and I'm certainly voting yes, so that the penalty for these monsters is death.
Thank you. I will bring my letters to full committee. I did not bring them. However, they do exist. And she said that they're rarely convicted. I think that's going to become even worse when people are afraid, especially familial victims are afraid to report this crime. And we are talking about life without possibility of parole. So they wouldn't be able to revisit another victim.
Representative Towns.
Mr. Chairman, obviously this is a very tough one, extremely tough. As you all are speaking and dialoguing back and forth and watching the audience, and typically, perpetrators are men and the victims are women, and in the old days, and I see the women shaking their heads, agreeing that they, for the most part, it's not scientific, that they think what you're saying is more accurate. And they're the ones that will feel the blunt of the victimization if it's a rape in the family, what have you. I'm watching their head and their movement. Now, you can juxtapose and compare that with men. We feel differently. Men want to kill you about doing something to their family members like that. I would want to kill you. If you turn them over to the men, we would kill you. It's just that simple. I'm being honest and raw, okay? And that's a hard place because you don't want to hurt the person that's been victimized, but you want satisfaction for what has happened to your person that you love. That's a Solomon question. What do we do? That's a question for Solomon and wisdom. What do we do in order to ensure that that person is protected in the future, that this never happens again, and that there's justice for it? What is the right answer? What is the right answer? Well, Solomon said you split the baby. You give half to this woman and you give half to this woman, okay? Obviously, he was able to smoke out the truth of who really owned the child, okay? This is a little bit more difficult for me to figure out what needs to be done in terms of the death penalty, especially while as a man, if I caught you, I would do something to you. You wouldn't need a death penalty because you're going to have it right there. But the fact of it is that when you're looking at the justice system, it's a little bit different. Now, Mr. Chairman, I would think that we would have, because the death penalty heretofore, and I've had mixed opinions on it, that we would be absolutely sure that because the death penalty has had biasness and all kind of stuff in it across the country for other things, not for rape or what have you, but just the death penalty itself, and innocent people have been by the state, killed. I would hope that if this passes, that we're thoroughly sure of what happens. Now, how does this compare to someone that we talked about earlier that may have a mental illness? Will the same death penalty apply to that person that we know is mentally something is wrong with them? Mr. Chairman, Mr. Leader.
Representative Lamert.
If it's a severe mental illness, then no. So both the U.S. Supreme Court and in our state statutes, both have agreed that when someone is severely developmentally disabled, if they have severe mental illnesses, all that is fought out in the court system. This penalty is reserved for the absolute worst of the worst. And I want to be very clear. I support the death penalty not because it is vengeance. It is not. Well, vengeance is when an individual is responding to a horrendous circumstance. This is justice, and it is deterrence. Again, that is why it is only reserved for the worst of the worst crimes. And in my opinion, and I hope you would find the ability to support this bill, but again, regardless of which way you may go, in my opinion, raping a child is equal in heinousness and evil than murdering someone. And we have the death penalty for murder. We have that. But we don't for rape of a child. In these children, in other bills and in other budget matters and everything else, we need to make sure that we support all of these organizations that support these children. And every single one of us should wrap our support and love around these children. They are valued by us. Enough so that when somebody does something like this, it is society that metes out that justice. It is not vengeance. It is justice.
Yes, sir.
Mr. Chairman, and that's the reason I'm saying the system has to be extra cautious, because as human beings, we want a little bit of both. As men and uncles and old folk that care about you, we want both, but the system is not supposed to operate like that. I concur 100%. But the emotion within a human being, you, especially the closer it is to the event, you want them both. And you want them instantly. That's not always going to work. I know that, but that's the truth of how human beings operate and function. And here again, everything you say is true. That's the worst of the worst. It's horrible. I can't think of anything any worse than that, except for maybe one or two things that we see in the news across the country. People do things that are just beyond the pale of human beings and how we treat each other, like setting a live person on fire. You have crazy people that will do that too. Human beings are evil. We have a lot of evil in us, and we will actualize that evil on another human being for no reason at all. It could be a perfect stranger, and that's a bad thing. But the most vulnerable, the children, have to be protected, like you say. I agree 100%. Mr. Chairman, one final question for you. Mr. Leader, have you found that this law been implemented anywhere else in the country? And if so, what are the results?
So there were several states that had this law in the books at the time that the U.S. Supreme Court said that you could no longer utilize this penalty. It was a 5-4 decision. Okay. We've seen other decisions by the U.S. Supreme Court be overturned. I believe that this particular makeup of the court, it leans more towards states' rights. They've had several decisions that have done that. This absolutely should be something. Criminal penalties, regardless of what they are, should be left up to the states for state offenses. It is illegal in the state of Tennessee to rape a child. It is illegal right now to do that. Right. We set the penalty on that. You all as legislators were elected to set that penalty. That my hope would be is that if this is challenged, and I anticipate it potentially would be, is that this would go all the way back up to the U.S. Supreme Court, and they would take the shackles off of us as a state and allow us the freedom to be able to have the type of penalty that we feel meets this heinous crime.
Mr. Leader, so what we're saying is that, and I agree here again, there is, at this point, to our knowledge, that no state in the union has done this as of yet.
There are other states that have discussed it. I personally don't know of states that have passed this law.
Right.
There may be one or two.
Right.
But while we're in the legislative session, I know we all stay so busy. I quite frankly don't look at what a lot of other states do. I just try to make sure that we're leading as Tennessee.
I know. And Mr. Chairman, thank you with that. Like I said, we have to do something. There are some other things I'd like to see some things done with, but especially our children. We have to do something. If you have a serial rapist, something needs to be done, no question about it. They're just kind of torn, but we'll see where it goes. Mr. Chairman, thank you for the bill.
Thank you.
Representative Davis.
Thank you, Mr. Chairman. So, Leader, my question has to do with duty to report. So if a child notifies either their teacher or someone else outside of their family about a rape or of this severity, do they have a duty to report? Does this bill impact any of that?
So this bill does not address any of that. So we would have to go to legal, and that might be something for them to pull the entire list of those that have a requirement to report. But there is a pretty significant list of those, mainly within professional careers, that have a duty to report child sexual abuse.
So even if a family member might feel concerned about reporting another family member, then those individuals that are around that child on a daily basis, that understand and see and know and or may have been, that child may have given that information to them, they, in my opinion, have a moral requirement to do so. And I hope that legally we have that duty to report as well, because everyone, all of us, we all have a responsibility to protect our children. And I think that this goes to do that. So thank you.
Thank you very much. And again, I will say this is not an automatic sentence. This is a sentence that once a jury reaches and goes through all of the evidence and everything else and reaches that burden that is, again, a phenomenally high burden for a reason, beyond a reasonable doubt that someone is guilty of this heinous offense, then they would have it's a bifurcated proceeding where then they would have a determination as to whether or not there are aggravating factors there to have the death penalty applied to that particular case. And so it is by no means just because somebody is reporting this type of heinous crime that the death penalty will be applied in every case. And in fact, what we've seen in the last couple of decades is that the numbers have gone down significantly where it is truly just reserved for the most heinous crimes.
Representative Johnson.
Thank you. Yeah, I just wanted to make clear that a lot of times it's the child who is the victim who will never report, even to a family member. I happen to have a letter from a victim that says that very same thing. She was terrified to report to her family and never did, and how it affected her whole life. So it's not always just that a family member's not telling, it's that the child may never report to anyone.
And I want to say this to those that are here and those that may be watching. If you're a child out there, an adult, and you're in fear because you've been abused by someone, we stand with you. We will protect you. We will be there. We will be there for you. And I understand that there is a lot of fear with this, but we stand with those victims each and every single time.
Any other questions for the sponsor? Seeing none, we're now voting to send House Bill 1663 on the full criminal. All those in favor say aye.
Aye.
Those opposed? No. The ayes prevail. If you wish to be recorded as a no, please see the clerk.
Thank you, Mr. Chairman, members of the committee, and thank you for your patience with me today. Again, I've had 4 bills, and probably most I'll have on a committee this year. Thank you.
Let's go to item number 8, House Bill 994 by Representative Keesley.
Motion.
You're recognized. There is an amendment with this bill, Amendment Code 5867. Is that one you wish to proceed with?
We do not. No, sir. No,
Okay.
Chairman.
Well, you are recognized.
Thank you, Chairman, members. House Bill 994 is known as the Citizens Arrest Bill. This bill decriminalizes holding a criminal at gunpoint until law enforcement arrives, as long as the crime is either directed against the person holding the criminal or a violent crime committed against a third person. In that person's presence. Now, it brings the law more in line with what people already believe that the law to be. The bill will prevent victims from being charged with a felony for standing up to their attacker. It also strengthens the victim's rights and safety over the protection of criminals. Is there objection? Of course. There's with a bill like that, like this, the law, let's just say, for instance, one objection is that the law already allows this. And the answer to that is, actually, it doesn't. Now, this is according to the research that's been given to me. It only allows the physically overpowering of the criminal, but only allows displaying a firearm as long as the fear of death is imminent. Another objection, could this justify vigilante? The answer to that is no. The bill only justifies victims of a crime holding the criminal caught in the act until police arrive. And finally, again, that the bill does not allow regular citizens to hunt criminals, as the crime has to be committed in the presence of the person making the arrest. Additionally, it has to be a violent crime in order for the display of deadly weapons to be justified. And that violent, some will ask, well, what are violent crimes? Of course, I have a list of those. There's actually 22. That's found in, I've got the code here, it's in section 3917-1301. And as I said, there's 22. Of course, from rape, murder, rape of a child, the list goes, unfortunately, endless almost. You know, the reason why I'm here standing in front of you with this is I've always been of the opinion that, for instance, if someone is attempting to carjack me, do I have the right, without being assessed with a felony or charged with a felony, do I have that right to hold that person hostage? I'll use that word, whether or not that term applies, but hold them until the police can arrive. Well, I've been told that I'd be charged, I could possibly be charged with a felony. Well, I don't want to be charged with a felony. And so I don't know, that's where we are. I'm not an attorney. There may be questions, members, that will be coming from you that I can't answer. As I say, I'm not an attorney, so I may have to refer Chairman to counsel to help me through this. But we'll there's 32 judicial districts across this state. Many of our generals are going to tell us that this isn't necessary. And it may not be within their judicial district, but there are some that I fear that there could be. Generals have a lot of latitude or discretion, in my opinion. So with that, I do know there's objection. I think there's some testimony that's coming in opposition to this, Mr. Chairman. I'll wrap it up right there with that. So.
All right, well, thank you. Well, members, we do have some that are here to testify, so we're going to go out of session. And we've got two here on the list. I'm going to call you up, and what we're going to do, ladies and gentlemen, is you can have a seat up here. You'll both have, everyone that testifies here today will have 3 minutes of testimony. We'll run those concurrent, and then we'll open it up to the committee for questions. So after you give your testimony, don't leave. Just please stay where you're at, and then members of the committee may ask questions if they so choose. We have a Kathy Barnett and Jeff Preppett. I hope I said that correctly. I'm sorry? Oh, Preptit. Okay. Well, very good. All right. You'll each will have 3 minutes. Kathy, if you would like to go first, when you start talking, please introduce yourself and who you represent for the record, and then your 3 minutes will begin.
Good afternoon.
And please make sure your microphone's on. I'm sorry.
It has the red
There
button.
you
There
go.
you go. There you go.
All right.
Good afternoon. I'm Kathy Barnett of Moms Demand Action, Tennessee. I'm a mother, a grandmother, and a retired teacher. I live with my family in Franklin, and we oppose House Bill 994. Under current law, a person is allowed to make a citizen's arrest when a crime has been committed. A private person may arrest another for a public offense committed in the arresting person's presence, when the person arrested has committed a felony, although not in the arresting person's presence, or when a felony has been committed and the arresting person has reasonable cause to believe that the person arrested committed the felony. However, a person is not allowed to threaten or use deadly force against someone while making a citizen's arrest unless it would otherwise be justified self-defense. House Bill 994 would dangerously expand Tennessee's citizen arrest law, allowing a person to threaten to use deadly force, including brandishing a gun, while arresting other citizens. Our state laws should encourage private citizens to avoid confrontation, not escalate it with threats of deadly force. The reason is obvious. In arrest situations, even highly trained police officers sometimes make mistakes. Innocent lives are lost. This will make it much worse. Citizens' arrest laws are a relic of a time before we had properly trained and resourced police force, and should be eliminated, not expanded. In addition to allowing citizens to arrest others without proper training or oversight, could lead to armed vigilantism and murder. After the murder of Ahmaud Arbery, for example, during which 3 men shot and killed Arbery while he was out on a run, Georgia made the responsible decision to repeal its citizen arrest law. There are too many cases where black men or teenagers are accused of committing crimes when in actuality they are cases of racial profiling. In 2020, a Florida teenager was on his way to basketball practice and was detained against his will by a vigilante claiming he saw him commit a crime. Thankfully, the teenager was not hurt and a police officer was able to defuse the situation. There are examples of confrontations like this all over the country that end tragically. We have skilled officers in Tennessee. We don't need vigilantes confronting people. Tennessee should follow Georgia's lead and end its citizens' arrest law, not expand it in a way that will endanger other Tennesseans. Untrained vigilantes should not be allowed to threaten violence in Tennessee, period. Please prioritize public safety by passing common sense gun safety bills that will save lives. Reject dangerous policies like expanded citizens' arrest, and please vote against House Bill 994. Thank you.
You were right on time right there.
Was I?
You sure were. So thank you for those remarks. Mr. Jeff, you'll have 3 minutes.
Thank you, Mr. Chairman. I'm Jeff Prep-T, and I'm staff attorney for the ACLU of Tennessee. I'm a proud Tennessean. I was born and raised in Bristol. Tennessee is my home, and like each of you, I want to make sure that Tennessee is a great place for people to live and visit. I come here today to speak against HB 994 because it does not make Tennessee a better place and will not have the intended effect of making Tennessee and its people safer. The issue with this bill is that it expands the ability to threaten deadly force without also tying such a threat to a duty to be responsible and reasonable. Under the current law, a person has the right to, quote, threaten or use force against another when and to the degree the person reasonably believes the force is immediately necessary to protect against others' use or attempted use of unlawful force, end quote. The law as it stands gives clear parameters that there must be a reasonable belief that the threat or use of force is immediately necessary to prevent greater societal harm. This bill eliminates that duty. A plain reading of the language of the bill would allow any person, regardless of any measure of reasonableness, to threaten to use force. As a gun owner myself, I recognize that I have an individualized duty to my whole community to own, store, and operate my firearm with the utmost responsibility and reverence. However, this bill would authorize the threatening of and the use of a firearm without regard to reasonable and responsible use of that firearm. Additionally, this bill creates a legal ambiguity that will cause confusion for Tennesseans. As amended, HB 994 authorizes the threat of deadly force where somebody commits or threatens to commit a, quote, violent crime against another. However, violent crime is not defined in this bill or in the statute that this bill is amending. In all actuality, violent crime is not defined anywhere in the Tennessee Code annotated. This creates an ambiguity to where any person could claim that a simple beam misdemeanor assault is a violent crime because it involves what most people believe and understand to be violence. It would allow that person to pull a gun and threaten its use on a person who simply says, "I'm going to slap you." I cannot imagine that this body would intend to allow a person to unnecessarily threaten the use of deadly force in the course of a petty argument. Like you, I feel a deep responsibility to make Tennessee the best it can be. However, HB 994 does not accomplish this goal, and I ask all of you to vote against it.
Thank you. Members, we've had several that wanted to ask questions on this. I don't know if they wanted to be on the bill or while we were out of session. Representative Halsey? Yes, go ahead.
Thank you, Mr. Chairman, and thank you for being here. Let's say with the sponsor's illustration, he pulls up at a red light, guy approaches him on foot. There's a car in front of him, he can't go anyplace, and the guy demands that he gets out of the car and give him the car, and he's holding him at knife point. If he chooses to exercise what's already in the law and make a citizen's arrest, he's got that choice because it's already law. But he doesn't want to worry about being accused by a district attorney or charged with a Class C felony of using a weapon to threaten somebody. What's his options? What do you recommend for him when you got crime is getting worse and worse in this state? What is his options if he chooses to make a citizen's arrest and the guy says, "I ain't sticking around"?
Yeah. Thank you, Chair Halsey, for this question. And so what I would state with this specific hypothetical is that the law as it stands actually does provide him adequate legal cover to be able to utilize his firearm to hold that person during a citizen's arrest. What the state has already previously done is expanded the castle doctrine into people's vehicles. So while a person's in their vehicle, they don't need to own or have a concealed carry permit. They're lawfully permitted to have that firearm. And if in the course of somebody committing that specific crime, that is something that this statute, as it currently stands, provides cover for. What this bill would then do is expanding that possibility outside of the scope of this specific hypothetical. If I could respond with another hypothetical, what this bill would essentially allow is for a person to claim that a simple shoplifting if they believe that that person has previously been trespassed from, say, Kmart, and they are then there to steal soap or baby formula or something. What they are doing is then technically a burglary, even though within the course of that, even though they are committing a crime, they're not threatening violence against another person. It would then allow another individual to pull out a firearm and threaten them with that firearm. And what I think is very important to note as well is that this also creates an ambiguity not only for the person trying to effect that citizen's arrest, but also creates ambiguity for a law enforcement individual as well. Because under the citizen's arrest statute, there actually is there's no duty to inform or to call 911. So if a police officer or law enforcement official happens upon the scene, they don't know what's going on, but you have this person who is trying to effect a citizen's arrest, who's pointing a firearm at that individual. Law enforcement are trained to respond with proportionate response. And I don't think anybody would want to see a law-abiding citizen then have to be facing down the barrel of a law enforcement officer's firearm. So I think the law as it currently stands provides cover for that hypothetical that you provided, but this bill would expand that and truly does create what I believe is a dangerous situation for most Tennesseans.
Any other questions for our guests while we're out of session? Representative Hardaway.
Thank you, Chairman, and good afternoon to you, sir. One of the first bills that I supported, Ulysses Jones was carrying it, State Rep Ulysses Jones, was to expand the castle doctrine to cars. Now, I'm a firm believer that you ought to be able to regard anyone that's trying to get into your car, no matter what their intention, the same way you would if someone was kicking in your front door. So I want to know from you and your interpretation of current law versus where we would be in TCA if this bill should pass. If someone walks up to my car and tells me to get out, let's say I forgot to roll the window down, I forgot to roll the window up and lock the door, so I'm looking straight in their face. Do I have to, because you spoke to if somebody was to slap you, whether deadly force would be a proportional and thus an appropriate response. Would I have to wait until there was some physical action on the part or of the potential carjacker, or if there was a display of a weapon or the display of a weapon in a threatening manner? Would on those three, tell me how current law versus where we'll be if and when this bill should pass.
Just so I understand the question correctly, you're posing a hypothetical where a person is attempting to effect a carjacking against you, but they haven't displayed a weapon or anything. Is that correct?
Correct. And I'm pretty good shape, but I don't want anybody slapping me. Okay? And if I think you're going to slap me, I'm going to respond, hopefully before you slap me.
So I'll address the carjacking situation and then move forward with the slap. And so under current law, as I stated before, it specifically lays out the language under which a person is allowed to utilize this force. So, and I'm quoting directly from the statutory scheme is under Tennessee Code annotated 3911, 611, and 612. So it reads, quote, that a person has the right to, quote, threaten or use force against another person when and to the degree the person reasonably believes that force is immediately necessary to protect against another's use or attempted use of unlawful force. So it's that attempted use of unlawful force. So if an individual is approaching your vehicle in a threatening manner and they are shouting at you saying, "Get out of your car, get expletive out of your car, I'm taking this," under the language of the current statute, you would then have the authority and have the right to be able to defend yourself and hold that person at gunpoint under the statutory scheme. And that was also expanded under the Castle Doctrine whenever it was expanded to people's vehicles. Because under the Castle Doctrine, if an individual, irrespective of the citizen's arrest statute, if a person is attempting to break into your home under the Castle Doctrine, under common law, you have the right to utilize deadly force to defend yourself. That doctrine was expanded to your vehicles with the act that this body took a few sessions ago. And so under those two statutory schemes and legal regimes, you do have the right to defend yourself if a person is threatening to carjack you. Now, when it comes to the example that I gave in my statement of a simple B misdemeanor assault, which carries a maximum of 6 months imprisonment, I don't want to get smacked. I know that you don't want to get smacked, but I don't think that in the course of if we are in the course of an argument and I say, Representative Hardaway, I'm going to smack you, I don't think anybody thinks that it is reasonable then to brandish a firearm due to what this state and what this body has deemed to be a low-level threatened misdemeanor offense.
Well, let me be honest with you. If I were one of these ladies in here and any man said he was going to slap me, I'd shoot him. And I'd empty that clip in it. Okay? Because I don't think you need to wait and evaluate and analyze, well, is he going to hit me hard enough to hurt? Or is he going to knock me off? Is he going to break my jaw? So I'm not sure where I am with you on the example that you use, because there can be instances where the individual who's going to be the victim versus the perpetrator are not balanced. So I'm not sure if I'm with you on that. But let me ask you, and then I'm going to relinquish my time here. How would the proposed law by the representative, how would his proposed changes in the law impact that same situation?
So if I may, I'm going to start with addressing the degree and trying to estimate the degree of force to be used. So under the current statute, it says threaten or use of force against another person when and to the degree the person reasonably believes force is immediately necessary. So in this specific situation, if there is an outsized comparison of the ability to defend yourself or to a person's strength, like if I am going up against Mike Tyson and he threatens to smack me, I'm not going to be able to sustain a slap from Mike Tyson. So under the current statute, I would then have a reasonable belief, and to that degree of that outsized force, to be able to affect that citizen's arrest. So under the current statutory scheme, it addresses that. So under this proposed amendment, like I stated in my statement, it eliminates that duty for reasonableness and to be responsible. So under the proposed amendment, what this specific section would read, it would be Tennessee Code annotated 3911-621. It would read, and I'm quoting directly, it would read, a private citizen in making a citizen's arrest authorized by law may use force reasonably necessary to accomplish the arrest of an individual who flees or resists the arrest, provided that a private citizen cannot use deadly force except to the extent authorized under the self-defense or defense of a third person statute. And this is where it would amend. It goes on to say, quote, a threat to use deadly force itself is not considered a use of deadly force for purposes of this section. A private citizen shall not threaten to use deadly force unless the arrest is for a violent crime committed or threatened against the citizen making the arrest, or a violent crime committed or threatened in the presence of the citizen making the arrest. So specifically, what this language allows for and what it changes is removes that duty for it to be responsible, proportional to the degree of what is actually threatened against that individual.
All right, thank you, Mr. Chairman. I got a third question, but I promise you that was the last one, so.
All right, well,
come
thank
back
you.
Later, please.
Any other questions while we're out of session? Seeing none, we're going to go back into session. Thank you both for your time here today. I've got a list of committee members that may have questions that are on the bill here. First is Representative Russell.
Thank you, Mr. Chairman, and to the sponsor, I appreciate you bringing this bill for us today. I do agree with the objections that you had. I'm being pro-Second Amendment, and I agree that a person should be able to defend themselves. I do have a problem if it's extended beyond imminent threat. And I've seen cases working in law enforcement with road rage and crimes of passion. I think you're going to end up with something like that if this bill proceeds. But I think, as a police officer, we're trained to use deadly force under certain circumstances, and it's pretty extensive training. So I'm just going to have to vote no on the bill, but I appreciate you bringing it.
Thank you, Representative Gillespie.
Thank you, Mr. Chairman. I'm going to make this short here. Representative Kiesling, or Chairman Kiesling, I understand what you're going for here, and but I'm going to have to say, because there's so many scenarios that I'm thinking where this could really backfire, and I'm just going to throw this out for the audience and everyone here, and you can respond if you want to. But my concern is, if let's say there was a fight between two rival gangs and they're shooting at each other, and the police show up, and the gang A says, "Oh, we're making a citizen's arrest." I've got some serious issues with that, and I think it can spread a lot further than just that same situation. That would also be extremely problematic and in reality make us all, I think under that scenario, everyone would agree that's not not good. So I'll just leave that there. And if you'd like to respond, I'd love to hear it.
Well, yeah, of course, anything is possible. I agree. You know, it's sad to hear testimony just now when racism was brought up. That has nothing to. This bill has nothing to do with racism. It has nothing to do with vigilante. Y'all. I don't appreciate that because it doesn't. Those of you are laughing or carrying on. You haven't even read the bill. But I don't. That's just not true. That does not apply to this. This has nothing to do with racism or vigilante. I made it perfectly clear of that earlier. But with that, Chairman, I'll close with that and return back to you, sir.
All right. Well, thank you, Chairman Halsey.
It seems to me, Chairman, that the intent of your bill is if you choose to make a citizen's arrest on a violent crime, you're just trying to make sure that you can't be prosecuted.
That's right.
For using deadly force to hold somebody,
That's exactly.
a threat or not a threat, if you're exercising a citizen's arrest. Am I right about that?
That's exactly right. Correct.
Okay.
Representative Towns? Okay. Representative Hardaway?
Thank you. Thank you, Chairman. And to the sponsor, there have been a couple of references to the definition of violent crime. Does your bill also include a definition for violent crime, or does it reference it in the current TCA, or does it list specific crimes? Tell me
May I refer back to the chair, and Chair, could you defer to council for that?
Yes, sir, we can.
get a
Without objection, we'll go
clarification
out
on
of
that.
session to hear from Legal Services.
Michelle Fogarty, Legal Services. The bill as written does not define violent crime, nor does it reference any definition in code of that term.
And what is there anything in TCA that would keep carjacking from being Mr. Chairman, I'll wait, and this was going to be too complicated for me to just put it out there like that.
All right.
So I'm going to try to simplify it in my mind, and then I'll come back later. Thank you.
Thank you. Any other questions for legal while we're out of session? Representative Halsey?
Just so I understand, maybe I'm looking at the wrong amendment, but it says a private citizen shall not threaten to use deadly force unless the arrest is for a violent crime committed or threatened against a citizen.
We didn't put any amendments on this bill.
There's no amendment.
My bad.
That's okay. Representative Fritz, you got something for Legal Services?
I do. Thank you, Mr. Chairman. Just the definition of violent crime, according to TCA.
So in 3917-1301, the code defines crimes of violence. In 4038-111, it also defines violent crime for purposes of that part, not for purposes of Title 39, though. And in 4038-111, violent crime means aggravated arson, aggravated assault, which results in serious bodily injury, aggravated child abuse, aggravated kidnapping, aggravated rape, aggravated robbery, aggravated sexual battery, aggravated vehicular homicide, carjacking, criminally negligent homicide, especially aggravated burglary, especially aggravated kidnapping, especially aggravated robbery, first-degree murder, incest, kidnapping, rape, rape of a child, reckless homicide, second-degree murder, sexual battery by an authority figure, sexual battery, stalking, statutory rape, vehicular homicide, vehicular assault, and voluntary manslaughter.
Thank you, Mr. Chairman.
Representative Towns, or Representative Fritz, you get your
Yes, thank you,
answer?
Mr. Chair. I just want to make sure we understood the severity of those crimes and what a violent crime is.
Okay, thank you. Representative Towns, you had something for legal services?
I did. Thank you, sir. Good observation. Legal services. In the scenario that the representative gave of a potential carjacking and trying to defend yourself, what kind of culpability do you have if you take your weapon and you put the person down, or you might even have to shoot him? What will a citizen be protected under current law?
Michelle Fogarty, Office of Legal Services. Under current law, there are two relevant subdivisions in self-defense. Subdivision B1 allows a person who is not engaged in conduct that would constitute a felony or a Class A misdemeanor, who is in a place where they have a right to be. They have no duty to retreat before threatening or using force against another to the degree they believe reasonably necessary to protect against the other person's use or attempted use of force. Subdivision B2 deals with the use of deadly force. Under that subdivision, a person who is not engaged in conduct that would constitute a felony or a Class A misdemeanor and who is in a place where they have a right to be has no duty to retreat before threatening or using force intended or likely to cause death or serious bodily injury if the person has a reasonable belief that there is an imminent danger of death, serious bodily injury, or grave sexual abuse, if the danger that's created by their belief of imminent death or serious bodily injury is real or honestly believed to be real at the time, and the belief of danger is founded upon reasonable grounds.
So from my analyzation of what you're saying is that if I was in that situation and I ended up having to administer bodily harm to the guy, that I would be protected and I could not be charged with a felony. Is that correct, or am I off base there?
Sounds like you would be using self-defense.
Certainly, because I did not perpetrate it. I'm minding my own business. I'm driving, trying to get to the next, my next event or what have you. Okay, well, I thought that needed to be cleared up. Thank you.
All right, thank you, members. We're going to go back into session. Chairman Hulsey.
Thank you. I don't think anybody that looks at your bill thinks the intent at all is for somebody to say, oh, that guy stole something out of Walmart there and he didn't pay for it, and I'm going to go over there and arrest him. And if he causes me trouble, I'll shoot him. I don't think anybody's looking at that. Would you consider rolling this for a week and clearing those kinds of, those are valid issues that these folks brought up.
Be glad.
And look at, if you can't do it, in a different way, adding an amendment that clarifies this is for serious stuff, and only if somebody chooses to make a citizen's arrest when they're in the defense of their life or somebody else's life. Would you consider that?
I would, Chairman.
Thank you.
Is that what you want to do?
And I would be glad to, Chairman. Back to you.
Without
Yes, sir.
objection, we're going to roll 1 week. Last item that we're going to pick up today on the calendar, House Bill 1628 by Representative Sapicki. You're recognized. There's an amendment code 11442. You wish to proceed with that?
That is correct, Mr. Chairman.
You are recognized on the amendment.
Thank you, members. This is a bill that we worked on with Chairman Hulsey and Chairman Doggett over the summer. We ran something similar to this last year, but found some obstacles on some creating special classes of people. And so what we've done this year, ladies and gentlemen, is we have amended this to where If you commit a assault or an aggravated assault in a healthcare facility, period, ERs, doctor's offices, emergency rooms, et cetera, that there'd be escalations to that crime as per already in TCA Code 3913-116 in regards to first responders or nurses. That's the bill, Mr. Chairman. I'll have to answer questions.
All right, thank you. That amendment that we just referenced, you were speaking on the amendment. The amendment makes the bill?
Yes, sir.
All right, well, let's vote now to attach Amendment Code 11442 on the House Bill 1628. Those in favor say aye. Aye. Those opposed? Ayes prevail. We adopt. We're now on House Bill 1628 as amended. Any questions for the sponsor? Representative Hardaway?
Thank you, Mr. Chairman. To the sponsor, will this bill protect not merely the professionals, the healthcare professionals, but also the patients or the families, et cetera, if they're within the facility?
Yes, the answer to that question is yes. Anybody in a healthcare facility would be protected.
Thank you.
Representative Chairman Holsey?
Thank you. And I just want to tell you, I appreciate you very much. The answer you gave him is what we issued, the issue we talked about, and you went and fixed it. And I appreciate that.
Thank you, sir.
Representative Johnson?
Thank you, Mr. Chairman. So this is already a crime, right? You're just making a difference when it's in a hospital, but this is already a crime.
Yes, sir.
As I referenced, Code 3913-116 already has these escalations for the first responders and nurses. This is going to apply that to healthcare facilities.
And so these mandatory minimums will take away discretion from the judge. Is that correct?
As already in Tennessee Code annotated 3913-116.
Thank you.
Any other questions for our sponsor? Seeing none, we are now voting to send House Bill 1628 on to full criminal. All those in favor say aye. Aye. Those opposed? The ayes prevail. You move forward. If you wish to be recorded as a no, please see the clerk. Members, we are at the end of our time. We appreciate everyone sticking out with us. All remaining bills on today's calendar will be rolled to next week. We are adjourned.